Good morning and welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I state your case, if the attorneys could please rise and state your readiness to proceed. The first case on the docket is C-24-548, and that's State v. Wilson Jones.
Josh Thompson on behalf of Mr. Wilson Jones, ready to proceed.
John Hill, on behalf of the state, Your Honor, ready.
Thank you. The next case is C-24-449, and that's State v. Jones.
David Hoffman for the appellant, Your Honor. Ready to proceed.
Chris Baxter, City, ready to proceed.
Okay, thank you. And then the last one is Sidlowski versus Fisher. That's C-24-570.
Full carriage, but Dr. Sidlowski ready to proceed.
And Frank Hosley, on behalf of the Yamaha defendants, ready to proceed.
Okay, thank you. Mr. Thompson, you can come on up. Would you like to reserve any time?
5 minutes, Your Honor.
Okay, I will be using the lights if I remember to use the lights. Green means go, yellow means you have about a minute left, and red means that your time has expired. Whenever you're ready.
May it please the court, counsel. The trial court in this case abused its discretion by denying Mr. Wilson Jones' application to seal his record because of its consideration solely of the number of convictions and the amount of time that had passed since his last conviction. Mr. Wilson Jones' 4th-degree felony conviction was eligible for sealing. He did not request expungement, and the final discharge in this case was on September 24, 2013. Now, this court said in State versus GH that a court cannot deny an application to seal solely based on the number of offenses if the records of those offenses are eligible for sealing under the law. Then more recently in JB, this court said the focus of rehabilitation is the applicant's progress following the last offense, not simply the number of previous offenses.
What sort of evidence was put on below about the progress that your client made between the last offense, which was in, was that 2017 or 18?
2021.
2021, yes.
A number of things. He actually submitted an affidavit indicating he had gone to Narcotics Anonymous, Alcoholics Anonymous, the TASK program, and various other programs along the way.
Well, let me ask you this. I think part of the trial court's issue or stated reasons for denying the application was because your client had been in similar programs earlier before and when he continued getting offenses, getting charges.
I would dispute to an extent the trial court's position of continuing to get charges. There was an idea that this was some sort of lengthy in and out of jail progress for Mr. Wilson Jones, but he had gotten probation on this offense and finished in 2013. 5 years later, picked up a new offense that he wouldn't have been in very long for that or had done it. I'm not sure if he did time on that, but the next thing came in 2021. So there wasn't a sign of some sort of massive failure. And I think that there are some differences that happened here that it seems, including going to therapy on his own, continuing once he got out of prison, abstaining from drinking and doing drugs, and enrolling full-time in driving school, truck driving school. So he had put himself in a better position than he had in any previous time, from what I can tell from the record. He also had a great deal of motivation to care for his daughter, get better housing for her, because right now, or at the time, he had a roommate, but could not have overnight stays with her without getting better housing. So essentially what I'm saying is that any consideration of the past would be outweighed by what he had done now this time around.
Thank you.
And I think that kind of gets into the things the court said, that Mr. Wilson Jones there had not been enough time that had passed since his convictions, and that he should come back in the next couple of years, and maybe he'll get those offenses expunged later. I'd note that in JB, cessation or continuation of criminal behavior in RC 2953.32 D1H3 is a subsection that is separated out for human trafficking offenses. That is the subsection that mentions cessation and continuation of criminal behavior, which is not applicable here. Now, I know the statute mentions rehabilitated to the satisfaction of the court, but the implication is if the language is different, the reasoning must be different, that it can't be cessation or continuation of criminal behavior, and I think JB recognized that. And then the legislature, when we're talking about time, has already essentially determined the amount of time necessary for eligibility. It's not an automatic, you're eligible, so you get your expungement, but it is saying, here's enough time that the state has decided for you to be eligible, and therefore not enough time for consideration should not be a consideration, if that makes sense.
Counsel, if this were to go back, if the trial court was just a little bit more artful or used some more words, don't you think the result is going to be the same?
I think the result will be the same unless this court just doesn't do that and explains. One, I don't think it should be sent back for findings, because it essentially is say it better, I guess, is kind of the instruction. And that can't be the result here.
Well, it seems the trial court was concluding that the other convictions demonstrated the lack of rehabilitation in combination with whatever all else the trial court has observed about the defendant. So you're suggesting we should just remand and order the judge to seal it?
I'm suggesting that yes, or the court, yes, order sealing. It's a tough thing, because without doing that,
It seems likely that the result
Yeah.
would be the same.
yes. And we know that the considerations that were stated on the record at the time, and the court knows the law, were the amount of time that passed, and that's essentially it, the number of offenses along the way and the amount of time that passed. It knows what the law is. Court knows what findings it needs to make, and that's what it relied on.
So, counsel, is it your argument that it was an abuse of discretion for the court to consider the amount of time that had passed since he had gotten out of prison?
Yes and no. That's difficult, because that's not the offense that he was seeking sealing for. So certainly enough time had passed there. If
When you say enough time, you mean statutorily,
Yes,
the minimum
exactly.
amount.
Right.
But I'm speaking more in terms of the holistic picture of whether or not he's on the road to rehabilitation. Is the amount of time that has passed something that the trial court could, within its discretion, consider?
yes, but not solely, I guess is how I'd say it. It can't be the only consideration. One could see it being a sign of whether someone is rehabilitated, but it can't be the only sign.
So what else what would be proper then? What are some proper bases upon which, hypothetically, upon which a trial court could deny an application for sealing?
A lack of evidence of rehabilitation in terms of not being able to say anything more than, I just want this because. Mr. Wilson Jones having put forward things he had done to actually demonstrate his rehabilitation is, I think, the important determining factor here.
But it sounds like the trial court can't solely base it on convictions
Correct.
and can't solely base it on the amount of time, but it can consider both of those factors in its consideration. Is that correct?
I think the court still needs to really speak to that issue. I don't think that they should be considerations. I think the legislature is clear in that in setting the eligibility. I think, honestly, the vast majority of the discussion should be the competing interests in maintaining those records. And here, Mr. Wilson Jones only shot ceiling, so the state would still have access to these records in any sort of relevant proceeding where they could get to those.
If you would like to reserve your time. is
Yes,
up.
thank you.
Mr. Hill?
I just wanted to start off by bringing something to the court's attention. Obviously, Mr. Thompson's arguments are heavily reliant on this court's prior holding in JB. Just did want to reiterate to the court that that case is currently under appeal in the Ohio Supreme Court. Oral arguments on that are scheduled for June 24th of this year. So to the extent that the court finds itself to incline to reverse based on the authority of JB, the state would request that it simply hold it for decision in JB, this case. Otherwise, we are of the position that the court should actually affirm what the trial court did in this case. Would like to start off with sort of some first principles relative to sealing and expungement. First of all, it's pretty clear by the law in the state that under Hamilton, which is 75 Ohio State 3rd 636, there's no substantive constitutional right to have an expungement. It's an act of grace, it's discretionary, it's a privilege, not a right. The second thing I'd like to point out is that, and I think Mr. Thompson touched on this in response to some of the court's questions this morning, that statutory eligibility is not the same thing as entitlement to sealing or expungement. It's something that a court can grant at its discretion where it believes that the applicant is an appropriate candidate for sealing and expungement. And then finally, the third thing is that obviously we're reviewing for abuse of discretion here, which means that the trial court's decision has to be arbitrary, unreasonable, or unconscionable. And there was some language in Jenkins that I really liked: palpably and grossly violative of fact and logic, such that it evidences perversity of will. I mean, it has to be pretty extremely off the mark here. And our position here is that the trial court didn't abuse its discretion.
Mr. Hill, how would you distinguish this case from the two cases that came out of this district?
This is going to be kind of glib, Your Honor, but what distinguishes this case from GH and JB is that in this case, the state actually objected to the applications. Maybe I'm reading between the lines here, but I don't think that this court took very kindly to the fact that in GH and JB, the trial court denied applications where the state didn't object. In fact, I think Judge Bergeron's decision in JB made it pretty clear that it thought that that was sort of a due process violation because the defendant wasn't put on notice that we objected. And here, you know, Mr. Wilson Jones had every opportunity to make his case to the trial court. He came in with, you know, an affidavit and a responsive memorandum to our objection that showed, you know, what he thought evinced rehabilitation. I would point out, you know, while acknowledging that the trial court essentially credited what he said in his application, that he was going to truck driving school, that he was going to therapy, that he was trying to do these things to better himself. You know, our position on this is that, you know, notwithstanding all of that, a lot of those things had been true at the time that he committed these subsequent offenses. I believe that the offense at issue in this case was the B11 one, which was like the first of 4 different drug trafficking offenses, the fourth of which had only been in 2021. It had been a felony 2 that was reduced to a felony 3. There was an F3 weapons under disability involved. He went to prison on it. He'd only been out of prison for 2 years. And again, all of the things that he said in support of his notion that he'd been rehabilitated, those were pretty much equally true at the time that he committed these other offenses at issue.
Does it make a difference that this was an application to seal the records rather than expunge?
I don't think so. I think it's a distinction without a difference, Your Honor, and here's why. I mean, one of the things that was implicit in the state's objection, and I probably could have done a better job in objecting, spelling this out more clearly, is that the public has a right to know. I mean, the public has a right to know who among us has been convicted of what. That's why we make these things public and keep them of record to begin with. And in future applications, I've tried to be more judicious in pointing that out to the court, just to try and inoculate them from appeal. But
Do you think it's true that, at least in my experience, many of these defendants, they didn't really even know the difference between sealing and expungement, and it was just
I mean,
happenstance that they were filing for something less than they could have got if they had wanted an
I think
expungement?
that is demonstrative of the fact that you were a trial judge, and probably you ran into some circumstances where applicants would file for one where they were only eligible for expungement, where they're only eligible for sealing, or they could be eligible for expungement, only apply for sealing. There is a distinct difference, and it's pretty minor, and it's, for most defendants' purposes, it's not particularly meaningful. Basically, sealing entails, removing the record from public view. It takes it off the clerk of court's websites. It doesn't show up in most commercial background checks. A potential employer, a potential landlord, anything, potential sporting association, youth sporting or whatever, you wanted to coach your kid's team or whatever, this stuff isn't going to show up for the vast majority of people. It just sits, unless it's expunged, in a government database where certain law enforcement agencies can access it for certain delineated purposes. I don't know off the top of my head what that statutory code section is. It's somewhere in 2953, 30-something. But for all practical purposes, for the vast majority of applicants, unless you're trying to get like a government security clearance or something, there is no meaningful distinction between sealing and expungement. So in terms of the public interest, they are essentially the same.
And the expungement, though, is more powerful in the sense that
It actually destroys the physical record. Right. But for most practical purposes, from a defendant standpoint, as well as, the public who might want to know among them who's been convicted of trafficking drugs 4 or 5 times previously, it's a very meaningless, it's a minor distinction, I should say. But I'd just like to close out, and I'm happy to answer any more questions from the court here. Given what the standard for an abuse of discretion here, I don't think that one happened in this case. I mean, the trial court articulated specific reasons, and I know it made reference, and this is why this argument is so reliant on JB, that it was the number of offenses. First of all, I would dispute that. It wasn't merely the number of offenses that Mr. Wilson-Jones had on his record. It's that he continued to commit offenses at, regular intervals, such that a trial court could find, well, only a couple years have passed. He's been convicted of this 3 prior times. Then he goes out and he picks up really the most serious of his offense. He just got out of prison, and all that he's offered in terms of rehabilitation are things that would have been true at the time that he committed those other prior offenses. So unless the court has any additional questions, I'm going to waive the rest of my time. Great.
Thank you.
Thank you.
Mr. Thompson, you have 5 minutes.
I would just note first that the application for expungement that is generally filed in these cases contains clear check marks to seal or expunge. So if we assume regularity, we have to assume that Mr. Wilson-Jones knew what he was doing and chose just to ask for sealing. So I do think that there is a significant difference because sealing still exists. And the state mentions the public's right to know, but if the public had a right to know, which it doesn't in this case, why would the legislature make it eligible? If they had a right, then there wouldn't be an opportunity for this to be eligible.
Counsel, I'm sorry, when you say the public doesn't have the right to know, the public doesn't have a right to know that people are violating
I would say the
laws?
public doesn't have a right to know forever. This isn't like ineligible offenses, crimes of violence, sex crimes, things of that nature that were explicitly made ineligible. So I was inartful there. My point is that it's not a permanent right. The records are public until they're not. I don't know how someone can have, quote-unquote, too many offenses or a number of offenses without continuing to commit offenses for a period of time. That's just how things work. Time has to pass between the offenses. So,
Counsel, how do you respond to the argument that all of the evidence of rehabilitation that your client cites were present at the time that he continued to commit offenses?
the answer is I don't know off the top, I don't know today the answer whether they were or not. I don't remember the time frame listed in the affidavit.
Would that be an important consideration?
It is an consideration, but I don't know that anything is more important than his status at the time of the application, at the time he is in the courtroom asking for sealing. I think the statute is clear that it is who you are now, not who you were in the past, that is up for consideration. If there are no further questions, I'll ask that the court reverse and order the trial court to grant Mr. Wilson-Jones's.
I do have a question as to the pendency of the previous case in the Supreme Court. The state seems optimistic in regard to that. Do you think we should simply wait?
I don't think that the court needs to wait. And the reason why is the question here is, did the trial court abuse its discretion as to Mr. Justin Wilson-Jones, not JB? So regardless of what the Ohio Supreme Court says, I don't think it will change what should happen with Mr. Wilson-Jones.
Thank you.
Thank you.
Okay. This case has now been submitted, and we will issue a decision soon. Thank you. Our next case is C-24-449, State v. Jones. Whenever you're ready, Mr. Hoffman, would you like to reserve time?
5 minutes for rebuttal.
Okay.
May it please the court, Mr. Powers. This is I'd like to confine my remarks to the first assignment of error, the speedy trial claim. And I wanted to begin by noting that in transcripts of other trials, the court may have noticed this as well. When these claims are litigated, sometimes with the discussion of prejudice, the prosecutor will say, well, there's no prejudice because I can still prove my case after all these years. And when a comment like that is made, it kind of shows a misunderstanding that prejudice isn't, prejudice is measured by what could have been in the record that may have benefited the defense, not whether the prosecution can still prove its case. And so we have the 4-part test with Barker versus Wingo that applies. The trial court didn't make many findings when it denied the motion to dismiss in this case. Arguments were made on either side, but with respect to the first of the 4 elements, the length of delay, there didn't seem to be much dispute that the triggering of this analysis was made with the 11-month delay. That the first element, the first factor was met, and so.
Counsel, how was your client prejudiced by that 11-month delay? What specifically occurred in that period that caused your client to be prejudiced?
Well, there was the destruction of the body-worn camera footage. It was pretty much understood that happened.
So what would have been helpful on the body-worn camera?
Well, I think there is a probability, fair probability, that the identification, the role that the driver's license that was found had in the identification was a little bit greater than what the witness might have, what Ms. Payne might have testified to. I think that at the motion hearing, Ms. Peterson claimed that the It was by means of that driver's license that the identification was made. I mean, it
So
might
you're
have
you're
been-
assuming that whole exchange would have been captured on the body-worn camera?
what was actually told to the officer by Ms. Payne, whether it was, yeah, this is him, here's his license, or I saw him face to face, I can recognize him, and what I saw matches the license. I don't know what was said. It could have been that I found this license, look, here's his license, we've got him.
But the license and her testimony were available, correct? I mean,
That is correct. That is correct.
so it's really kind of retrospective speculation that it would have been different, what she may have said during the body-worn camera. It may have been helpful, it may have been hurtful.
True. But the trial court made sort of a finding in this when it suppressed that body-worn camera.
And why didn't that fix the problem?
Why is that?
Why didn't that fix the problem?
Because it goes back to this assumption of mine, that remember the first assumption I made at the beginning of my comments about the prejudice being measured in terms of what the prosecutor can prove rather than what might be available to the defense. It didn't fix the problem. First of all, case law says that when you have a violation, when you do have prejudice, dismissal is the only viable remedy. And the reason why is because by squelching what the prosecution can say, it doesn't remedy the fact that there may be evidence of innocence in what was lost.
And what's the standard? You referred to maybe. Is it actual prejudice or the potential for prejudice?
I can't remember, Your Honor. I think it's, I would be guessing. I don't know.
Okay.
I'm sure there's not, it can't be like beyond a reasonable doubt. It must be a fair probability or something like that.
Now, you've expressed your concern about what possibly could have been on the camera. Let me ask the question differently. Do you have any evidence of actual prejudice that your client incurred as a result of the destruction of the body-worn camera footage, or any other actual prejudice?
No, sir. The trial court's suppression of the testimony reflected a finding, implicit finding that there was prejudice, though. And so I think that is something this court could rely upon, that holding that the testimony should be suppressed due to the delay and the destruction of the body-worn camera. It wasn't a separate determination. It was mixed right in with the motion. While these factors were being argued, the trial court wanted some guidance on what to do about this destruction of the body-worn camera. And it was the prosecutor that brought up the suppression of the testimony. The trial court denied the motion. If this had been a motion to suppress, the motion would have been granted. The only reason why this dismissal was denied was because the trial court felt it could get away with suppressing this testimony and cure this speedy trial problem. I think the trial court found a problem and tried to remedy it by suppressing the testimony. The case law says you can't do that.
So I want to get back to the prejudice question. So you either have to show actual prejudice or excessive delay presumptively compromises the reliability of the trial. So are you arguing that prejudice should be presumed here?
That's a good question. I didn't think about that. I think that there's enough delay to allow a presumption. That first factor, the triggering mechanism, is based upon a presumption of prejudice. There was an actual testimony of destruction of the body-worn camera footage, and there was a suggestion that the identification came from the license and not from eyewitness face-to-face observation of the defendant. So I think both. I think it can be presumed, and I think there's evidence of actual prejudice.
Okay, so what the case law says is that excessive delay presumptively compromises the trial. So 11 and a half months, is that a long enough time where we can presume that there is prejudice? Have you read any, okay, I guess a better question here
Okay.
is, have you found any cases where 11 and a half months, 12 months, 11 months, in that area, that was enough to presume prejudice?
I can't
Under
recall
the
any
fourth,
right now.
under the last factor?
I can't recall, but I do remember the language in Barker that says that none of these factors are determinative on their own, that there is a balancing here that has to be made, and that prejudice, actual prejudice at least, is not essential to the claim.
But only if the delay is long enough that you can presume prejudice.
Correct. I want to touch on the reason for the delay. The Barker opinion seems to indicate that the fact that a motion is made is sufficient to satisfy this factor about the assertion of the right. Sorry, I mean the assertion of the right, factor 3. I wanted to discuss that factor. There was a delay of a couple months in this case before the motion to dismiss was filed. There are cases that say that the mere filing of a motion to dismiss is sufficient to cause that factor to weigh in favor of the defendant, irrespective of the delay in making the motion. Because there's language in Barker where they tried to go over different ways to assess how this right to a speedy trial can be raised, and they didn't want to make it a demand right. They said the Constitution, the right to a speedy trial in the Constitution basically is not waivable just by silence. It's too important. There has to be an affirmative waiver, and so the failure to raise it alone should not be considered a waiver. And constitutional right now I'm talking about. Our statute is different. But with respect to this delay in serving a complaint, that language does apply. And also the Barker opinion said that they didn't want to require an automatic filing of a motion to dismiss as soon as counsel is appointed. And they said it's sufficient that the right is asserted, and they didn't go over a time limit. They did say that if a person is bothered by the delay, it would show up in how they're asserting the right. But they didn't say that they required an immediate filing of the motion to dismiss. So I think the delay in this case, it weighs, the fact that a motion was filed, that factor should weigh in favor of the defendant.
Mr. Hoffman, if you'd like to reserve your time has expired.
Thank you. I'd ask that the court would reverse the discharge. Thank you.
Thank you. Mr. Powers?
Morning, Your Honors. Counsel.
Good morning.
May it please the court. The trial court in this case appropriately weighed the factors of the four-part test of Barker v. Wingo and did not err in its conclusion that the length of the delay, the reason for the delay, and the defendant's assertion of the right, the prejudice to the defendant was not sufficient to grant a motion to dismiss.
What was the justification for the delay in this case? I mean, they found his license right there at the scene, right?
We conceded at the motion that the reason for the delay was primarily on the officer on the scene not following up on that case that contributed to why her testimony was ultimately suppressed at trial.
So there was really no justification for it?
Not from the officer's standpoint, no, on that sense.
Was it a situation where she just decided not to follow up on this particular event?
I can't quite speak to why she may or may not have followed up. I don't know if maybe she put it into a central warrant situation where she assumed somebody else was going to follow up on it. I don't know not entirely sure where that ball got dropped.
Of the four factors, which do you think weighs most favorably for the state?
I would argue actual prejudice, because the reality is that, as what defense counsel was speaking to earlier, there's a heavy assumption of what Officer Peterson's body-worn camera and testimony would have provided to this. There's also the nature of the offense itself to consider. This was a hit and run. The defendant was long gone from the scene. The alleged events had already transpired well before Officer Peterson was even on the scene. Furthermore, we still had tangible, real evidence in the way of a wallet with an identifying government ID, as well as a Cash App card with his name on it, and a prosecuting witness who could testify that she remembered the night vividly, and she could tell us specifically why she remembered it vividly. She was asleep on her couch. She was in the nude when she heard a incredibly loud crash early in the morning, ran outside with nothing more than a blanket, and had to run down the street, and this was after she sees Mr. Jones the first time backing away from.
So how far,
Why does it, I'm sorry, go on.
how far away was she, like, her identification of him to match the license?
I believe-
in the middle of the night, how reliable?
I believe she said her yard is not very long. I'd have to check the transcripts for what she exactly said, but I think it was in the realm of like 15 feet away, 15, 20 feet, and that she was able to run outside, cross the yard, and see him through his windshield before he drove off. His
But
car
that's the ID, and then they find the license plate,
Yes, that was, she
or the
followed.
license, right?
Yeah, she followed, her and a couple of her neighbors followed down the road because he drove off, and they didn't think he was going to make it very far because there was significant damage to his car. That was when she witnessed Mr. Jones getting out of the red Mazda, see something fall out of his lap. That's where she gets a even better look at him because now they're in a parking lot with better lighting, and he flees the scene on foot at that point. She finds the wallet that has his identification in it.
So your position would be the body-worn camera relaying the information to the officer wouldn't have made any
At best, it's
difference?
corroborative, and I think it is of minimal probative value when the primary evidence for the state's case in chief was the testimonial evidence, which we went to trial on, and the jury found insufficient for, that was the ultimate conclusion at trial. We were limited by the officer not being able to testify, and I believe the jury did actually hold that against the state in our case in chief. So if anything, I feel like the defense was benefited from the lack of body-worn camera, because the odds of it having some sort of exculpatory evidence is a pretty big leap in assumption, whereas it is far more likely, in my opinion, that it simply corroborates the testimony that Ms. Carlissa Payne gave, on her direct.
Counsel, what about this argument that if there is undue delay, the only solution is dismissal? Do you agree with that?
I do not agree with that. I think that that is too broad a generalization. I think that if there is a specific issue with the case, here the specific issue was Officer Peterson had no recollection. She was not able to testify to pretty much anything. That was an issue. But with that being said, I don't think that the state, I was actually the trial attorney on this underlying case. She wouldn't have been a probative attorney, a probative witness anyway with that recollection. So at that point, we probably wouldn't have called her anyway. So we just comply with the limiting instruction. She can't testify that way. She can't provide any sort of conjuncture or any false memory because she's already said to the trial court that she cannot remember. So we just cut her testimony out completely, leave it with the person who swore under oath that she could confidently, vividly recall this night because she chased after him wearing nothing but a blanket down the street.
What does it matter what she was wearing?
I think that it helps serve for the corroboration of how things imprint in our minds. Some days are forgetful, some days are forgettable. I think a day that you chase after a guy who just wrecked your car into your front yard in the nude wearing a blanket is the type of day that you would have a very vivid memory of. That's why I bring that up.
So, counsel, I'm trying to get my head around this idea of prejudice. The state had no explanation or excuse or reason for the delay. but is asking the defendant to take the risk that the suppression of the officer's testimony was enough to avoid any other prejudice that resulted from this
Well,
unexcused delay.
Well, I would argue that the delay itself here, there's the emphasis here, it's explicitly stated there's no bright line time period for delay. But the emphasis is instead on the purposes served by the Sixth Amendment, namely preventing undue delay and oppressive incarceration, reducing anxiety and concerns accompanying public accusations, and limiting the possibility that a long delay will impair the ability of the accused to defend himself.
Yeah, and that's the piece I want to focus on.
Okay.
You're asking the defendant to bear the burden of the delay that resulted from your clients not pursuing this in a timely fashion. Because we're guessing as to what would have happened had there not been a delay, right?
I'm sorry.
We're guessing as to what would have happened, what the evidence would have shown, how that would have impacted the jury. We just don't know. But you're asking the defendant to bear that risk.
I concede that factor should weigh slightly against the state, but in the grand scheme of the balancing factor of the four-part Wingo test, we find that it should still weigh in favor of the state, given the totality of the circumstances.
Have you found any case law that talks about when, in the fourth factor, is what constitutes excessive? What constitutes excessive? So that prejudice is presumed rather than the defendant having to affirmatively show prejudice.
I have not found anything explicitly stating when prejudice becomes assumed.
I'm not saying a bright line rule. I'm just saying, have you read cases where the court has said that number of months or years or whatever is enough? That is excessive, so we will find prejudice, simply because it was so long. Have you found any cases where a court has found that?
The closest that comes to mind would be probably Benton, but I believe that serves mainly as a triggering mechanism for the.
Yeah, I'm not talking about I'm not talking about factor one. I'm talking about factor four.
Yes, so as for factor four, no. As for factor three, I know that State v. Jackson says that if a defendant sits on his right to assert the speedy trial rights.
He asserted it before trial, though.
But you agree that at some point the delay becomes so long that prejudice should be assumed?
Potentially. I am not sure how to quantify a line in the sand for that. When does a length of time become prejudicial? I mean,
Say, for example, would a decade be too long, 10 years?
I mean, even then, I think it would involve it would be much more likely at that point, but I think here I think it's fact specific. I mean, we had an entire motion where we had our primary prosecuting witness testify under oath as to what she could and could not recollect.
So there's no default length of time with prejudice?
I do not believe that would be a fair way to do it. Every prosecuting witness would be different. Every prosecuting witness interprets things differently. Every people retain information differently. And I think it would be more appropriate to gauge them on a case-by-case basis and have the trial court, as the person in the position to best judge credibility, see as to whether or not the trial court believes that this is still a fair proceeding, a fair recollection, that whether or not the time that is passed between the events and the motion have sufficiently tainted the evidence by way of loss of physical evidence or loss of memory. And here, although we did lose physical evidence in the way of body-worn camera, we had, several other pieces of physical evidence, namely his own ID. So I know that there is a assumption to be made here, but I do genuinely believe it is far, far, far more likely that the conversation between Ms. Payne and Officer Peterson that was captured and then lost on body-worn camera would have simply been, this is the guy I saw, this is his ID.
But we can't assume that.
I don't think you can assume either way. I think it's an even grander assumption to assume that it would be exculpatory in nature. I think it is more fair to assume that it's neutral.
Okay.
If there's no further questions, I would just ask that you uphold that state's ruling. Thank you.
Thank you. Mr. Hoffman, you have a little less than 5 minutes.
I'm not sure how helpful this will be to the court, but I did remember some language about excessive delay. And the language I remember indicates that it isn't based upon necessarily the likelihood that evidence was destroyed or that favorable evidence was destroyed, and it has to do with the conduct of the state. In other words, if the delay can be shown to be tactical on the part of the state, then delay will not be tolerated. The delay will be considered prejudicial even with a little bit of delay. If it's
So would you characterize this as tactical delay? It seems like.
No, I'm not. I'm
It
just
seems
telling
like
you that,
inadvertent delay.
yes,
Or
negligence.
bureaucratic delay.
Negligence is not a good reason for delay, but it's not as bad as tactical. And then you've got reasonable diligence. If the state exercises reasonable diligence, maybe 10 years would be seen as not excessive. In this case, though, it isn't just ordinary. It is negligence. It's just negligence. But it's unusual negligence. I mean, they had his driver's license, for heaven's sake, with his address and name. I mean, you can't get any more reliable information of a person's address and contact information than a driver's license. And they had it for a year almost. I think that would be way in favor of the defendant. I think all 4 elements weigh in favor of the defendant, and the trial court erred in granting the motion.
But just out of
denying the motion.
out of interest, what is the statute of limitations? These are what kind of misdemeanors?
These are
minor misdemeanors.
one's an unclassified misdemeanor
So that's,
that prohibits jail time. I have no idea.
I mean, it's got to be a really short statute of limitations, right?
It is, yes.
So
But I
we're
can't-
11 months in. It might be a 12-month or a 2-year statute of limitations.
Correct. I just also want to mention that there's language in Barker and State versus Grant that indicates that dismissal is, if you find a violation, constitutional violation of speedy trial, dismissal is the remedy. And it's for the reasons I mentioned. I don't know if my ears might be more sensitive, but I thought I heard during Mr. Powers' address to the court that the language, we can still prove it. He talked about how strong the case was. And that's not the issue here. The issue is what could have been in the body-worn camera.
Counsel-
Yes, sir.
You said dismissal is a remedy.
I mean, I didn't mean to
Is
say
it-
that's the
is it
remedy.
the remedy?
The remedy.
Okay.
And the officer testified.
I'm going to piggyback on what he said. When you say it's the remedy, is that because of a constitutional violation, or is that a statutory violation?
Let's see. If it's statutory, that would be the remedy. And if constitutional, according to Barker versus Wingo and State versus Grant, that's the remedy for a constitutional violation as well.
Okay, thank you.
The officer testified, Officer Peterson testified, when asked how she could identify Mr. Jones as the driver, she said it was due to a wallet left at the scene. And what are we supposed to take from that? What might be on the body-worn camera? I'm just talking about her testimony now. I know what's her name? Miss Payne, sorry. She testified differently, that it was her eyewitness testimony that identified him. But Officer Peterson said it was the wallet. She said it was the wallet that allowed the identification. I mean, what was on that body-worn camera? And then again, she testified also, the witnesses on scene were able to identify the picture on the driver's license, which was the defendant, as the individual driving the vehicle. I don't know, I think there's some suggestion that there's a good chance that body-worn camera might have had something good on it for the defense. I mean, it doesn't have to be an acquittal, it can be favorable. But anyway, so based upon these comments, I'd ask that the court would reverse and discharge.
Thank you. This case has now been submitted, and we will issue a decision. Enjoy the rest of your day. Okay, now we have our final case of the day, C-24-570, Sidlowski versus Fisher. Mr. Carriage, would you like to reserve any time?
4 minutes.
4 minutes, gotcha. Whenever you're ready, you may begin.
May it please the court, my name is Paul Carriage and I represent appellant David Sidlowski and the estate of his daughter Ali. We're going to talk about the trial court's summary judgment decision and the dismissal of the warning claim and the design defect claim, but before I get to that, I don't want the reason we're here to get lost in the weeds. Ali was killed by carbon monoxide emitted from a Yamaha boat. There's no reasonable dispute about that fact. What we're here to talk about is whether Yamaha should have done more to stop that death. So the record evidence would allow a reasonable jury to conclude Ali would not be dead if Yamaha had included adequate warnings on the boat or designed the boat differently. And that's the problem with the trial court's decision, is that the trial court looked at some of the evidence, weighed it, disregarded other evidence, and at the summary judgment stage, that's reversible error.
Before you go on, I do have a question about Dr. Weaver's testimony.
Yeah.
So I reread the transcript yesterday, and it appears that his opinion stated that her sitting on rear seats, platform, whatever you want to call it, that was a contributing factor to her death, and that her being, but if it were that alone, if she hadn't have gotten in the water, she wouldn't have died. But the fact that she was exposed to carbon monoxide in those seats or on the platform, and then got in the water, that it was a combination of the two? Am I understanding that correctly?
Right, so the exposure while seated in the rear-facing seats was a proximate cause of Ali's death, and the time behind the boat, the bolus that was taken on by Ali when she was behind the boat, was also a proximate cause. And I think what's really important is the article there. The Ohio standard is a proximate cause, not the proximate cause. There can be more than one proximate cause for a death. So I think the question is, if Ali hadn't taken on any CO when she was in the rear-facing seats, what would be the situation? And according to Dr. Weaver's testimony, she would not be dead. So that kind of sort of answers that question, because you have to look at a little bit broader part of his testimony. I believe his phrase was, Ali would be alive today if she had not sat in the rear-facing seats. So we'll concede gladly that there was CO exposure behind the boat. For the summary judgment purposes, it was 30 seconds, because that's the fact in the light most favourable to the non-moving party, and that there was some level of CO. The level of CO in this case was 34%, and Dr. Weaver said it was impossible to take on 34% CO intoxication, even if Ali was behind the boat for 10 minutes. So, yeah.
Was there any dispute about the amount of time she was behind the boat?
There is a dispute.
So is that a factual dispute that precludes summary judgment?
Absolutely.
So your position is a minute or two, and their position is what?
Their position, I believe, is it could be as much as 10 minutes. Our position is 30 seconds. So that there was a testimony that she was behind the boat for 30 seconds to a minute. So 30 seconds, that's the light most favourable to the non-moving party. I want to just turn my focus for a second to the warnings claim.
Do you think, looking at this, it seems like the trial court was critical that there wasn't a specific expert on the design defect, but the failure to warn claim, it seems like it's more based on the actual location and size of the warnings, as between the design defect and the failure to warn. What, do you have an expectation? Which one did you think was more likely to survive summary judgment?
So I think the design defect claim is really easy. I plan to spend 30 seconds on it. There's 8 factors. The trial court considered 1 of the 8 factors and disregarded 7. That's an error. If you actually examine all 8 factors, all 8 are in favour of reversal. But even if you took the trial court's examination of just warnings, it would still be 7-1, and then that's got to be decided by a jury weighing of those factors. I really don't have a lot more to say about the design defect claim because I think it's so easy. There's a seat in a kill zone. A reasonable jury could decide that's a design defect, and I just don't think there's a lot more to say about that because it seems so simple. And I'm not sure, you sort of mentioned the trial court's comments about there not being a design expert. So Robert Swint is an expert in human factors. He was in the engineering crew for the Apollo missions, and I have a quote written out in prediction of that question, so I just want to read it to you real quick. A boat designer must not put seats in a location where people could die if indeed they sat in those seats. Any reasonable boat designer would know that no matter what warnings are used, people will sit in those seats and be exposed to this danger.
So it's not the lack of the catalytic converter. It seems like the trial court was critical because there wasn't expert testimony about the lack of, but you're saying that's really a red herring.
It is a red herring. The catalytic converter is all about, there's an affirmative defense based on technical and feasible alternative designs. The catalytic converter discussion is all about an affirmative defense. It's not about the design defect itself. The design defect is putting seats in a kill zone, an invitation to sit in a place where you can die. That's a design defect. And there's plenty of testimony from experts in the record that that is a design defect. And a reasonable jury could believe that. So,
And is this rear seat design, is that unique to this particular model of Yamaha boat? I mean, are there other boats that have similar designs?
to the best of my knowledge, it is rare. I don't think it is exclusive. But like, look, I'm not an expert on boats, and I'm not an expert on and I'm certainly not an expert on boats other than this one. So I couldn't tell you what, 20% of boats have that. I couldn't tell you the answer to that question, but I don't think it matters because it just would mean that 20% of boats were defectively designed. And again, a jury would be perfectly entitled to determine that. And I don't want to flip between topics, but I think it's related that there was a citation issued by an industry inspector specifically about the rear-facing seats and misleading information about usage of the rear-facing seats.
And that was 10 months before the death?
That's about right, yeah.
Okay, and where is that in the record? It is in the record.
It is in the record.
Okay,
absolutely.
that's
Yes,
really what I
it's
mean.
definitely in the
Sorry.
record, and it's attached to the summary judgment pleadings.
Gotcha, that's fine.
Yeah, you're testing my memory more than I was ready for.
Sorry.
So I'm going to flip back to the warnings just because I want to make sure I talk about them plenty. There are 5 standards for warnings. There's specificity, clarity, conspicuousness, avoidability, and audience. And I want to talk about some more red herrings because of the audience requirement. So there's a manual that is for operators. Ali was not an operator. Whatever's in the manual was given to, that information was given to someone else, the boat operator. If Yamaha wants to argue to a jury that we can kind of rely on an intermediary, that's something Yamaha can argue to a jury. But as a matter of law, there's no, well, a boat operator is an intermediary and therefore we win. That's not a law, that's a fact issue.
Would there be a comparative fault sort of assessment at trial in this particular situation? It seems like there's a lot of potential fault to be divvied up.
Absolutely. The jury should be, assuming the arguments are right, yeah, an apportionment interrogatory or something like that would make complete sense. But that's not what we're talking about in the summary judgment standard. We're talking about, is there enough apportionment for Yamaha that the jury should decide what that is? And it seems to me that these points, I think there's lots of ideas that maybe a jury could decide this and maybe a jury could decide Yamaha's not very much at fault. Well, maybe that's right, but that's not what we're here today to talk about because this is a summary judgment standard, not a sort of bench trial where it's not a manifest weight argument, which is what it seemed like the judge really kind of maybe put his thumb on the scale a little bit and said, well, if you ask me, it looks like maybe Wyatt was more at fault than Yamaha, so now I'm going to dismiss the claims as summary judgment. And that's just not the summary judgment standard properly applied. So I'm going to keep fighting back to get back to warnings, I promise. So there's a manual, a training pamphlet that may or may not have been given to the boat operator, and an IMA guide that was given to the purchase of the boat, which is the boat operator's parents. None of those were provided to Ali. So just that fact alone means there's an issue of material fact regarding audience. So if there's an issue of material fact regarding audience, then it goes to the jury as to whether the sort of abdication to an intermediary is an acceptable way to issue warnings. The on-boat labels are, I have a little bit of a hard time it sounds like I'm being flippant. It's size 9 font. My eyes aren't perfect, but I don't know how closely you read the brief. There was a challenge to try and read size 9 font from 4 or 5 feet away, and I couldn't do it with my glasses on, let alone my glasses off.
Okay, let's say hypothetically that the warnings were placed in a way that somebody could see them. Can you?
So you say could or could not?
Could see them and could read them, and they were conspicuous, hypothetically.
Sure.
These specific warnings, which warning would you say came closest to warning passengers about the danger sitting in those seats?
There is not a single warning that addresses on any level the danger of CO2 to a person sitting in the rear-facing seats
Isn't there at least one that has some sort of puff of smoke?
behind the boat. The puff of smoke is behind the boat, not in the rear-facing seats.
So you're saying that that puff of smoke in that label should have been demonstrative of the puff of smoke over the platform?
I'm saying it should have said on the seats, don't sit here when when the engine's on, because if you do, you might die, or from carbon monoxide poisoning, or something to that effect. You can't have a seat that invites sitting. This is like, there's expert testimony on this exact issue. I see I'm running out of time, so I'm going to try.
I'm actually going to give you a little bit more time. This case is a little more complex, so I will give both sides.
So there's expert testimony in the record saying that the seat itself is such an obvious anti-warning that the warning themselves are overwhelmed by the existence of the seat. So if there's a seat that says don't sit here on the seat, that would still be sort of, well, that doesn't make sense. Don't sit in this seat is sort of an internal contradiction in itself. Now here, of course, the instructions are if you're seated in the seat, you can't see the instructions, and they still don't say don't sit in the seat. They say don't swim behind the boat, and if you have CO symptoms while swimming behind the boat, move to fresh air, which is of course exactly what Ali did. She smelled. Now smelling gas is different to CO symptoms, but I think we can connect those dots. Ali smelled gas. She moved to fresh air in open water. So to the extent there was an instruction that was relevant here, it told Ali to do exactly what she did. And then she drowned because she was in open water when she sunk under. So I don't think we can get to, now, other warnings about jet streams that just, that's nothing to do with CO. Remain seated when the boat is moving is the label that's closest to the rear-facing seats. Well, remaining seated is what Ali did when the boat was moving. There's an instruction in the manual that instructs the operator when people are at the rear of the boat, the engine can be turned off or in idle. Well, the boat was in idle when Ali was swimming behind the boat for that 30 seconds or so.
So I want to touch on that a little bit more. So I asked you earlier about the contributing factor. So that when she was actually in the water,
Yes.
so it says in the manual that it can be in idle?
Yes.
Okay, but it also has a warning not to swim close to the back of the boat.
There's a warning that says, there's a warning on the area
Right.
behind the feet that says, don't swim behind the boat. If you get CO symptoms, move to fresh water.
Right.
Now, you can't, of course, get off the boat without being behind the
Sure.
boat. So, and remember we're summary judgment, it's 30 seconds. And so I tried this, and hopefully you'll take my word for it. I couldn't read that label in less than 30 seconds. So then I would have to read the label and then move away, and that would be too late.
How many people were on the boat?
My understanding was it wasn't consistent, but the most was 15.
So the whole backside of the boat was occupied by numerous people, in
The-
addition to Allie.
So, there are 14 seats on the boat, and then at times there were people wake surfing, and there were times people using jet skis. So it's not always clear what the occupancy was at the particular the moment that Ali died. It's not clear how many people are on the boat, or at least I don't know that part of the record. But you go back to the seating chart, and the reason the seating chart, and it's really, the seating chart's not really the issue. It is an issue, but really it's the citation that led to the seating chart is the issue. And the citation it's misleading about boat occupancy. The citation was issued because it looks like you can seat more people than you are permitted to seat, because the rear-facing seats exist and are not plainly identified as only to be used when the boat is off or when the boat is, when the engines are off, in contradiction of the manual that says idling's fine.
Okay, your time has expired.
By a long way. Thank you so much.
And I will add 4 minutes to your time.
Thank you very much, Your Honor. I very much appreciate it. Good morning.
Good morning.
May it please the court, Frank Hosley for the Yamaha defendants. I'm going to try to clean up some of the things that counsel just told you that are not supported by the record. Let me just start with where he ended. This citation that he's referenced in his brief several times. Judge Bach, he asked him where that was in the record. He couldn't give you a citation because it doesn't exist. It didn't happen. They're making that up. It's not in the record anywhere. What happened in 2018 is the seating chart for the boat was certified by the American Boat and Yacht Council as complying with the standards. 2019 and 2020, going all the way back to 2010, it was certified as complying with all the standards. In 2021, for 2021 model years, the ABYC inspector told Yamaha, we're changing the way we want to demonstrate designated seating positions. In the seat, we want you to show the testimony from Brandon Spicer, which is in the record, was we want you to show butts in seats with dots. And Yamaha said, that's fine, that's what we're going to do. But the seating chart for this boat showed 10 people can sit in the boat in designated seating positions. And the seating chart that came out for 2021 models, as requested by ABYC, showed 10 seating positions on the boat, designated seating positions. There was no difference in where those positions were located. There was no citation given to Yamaha related to you're telling people to sit on the rear seats. There aren't any rear seats. There is a swim platform.
Oh, wait, I'm going to push back a little bit on that. So in the back, there are places that look like chairs. They have cushions, they have cup holders, they have, I think it was a way to change the stereo or do something with the stereo. I'm really struggling to understand how those aren't seats.
Well, Your Honor, there's designated seating positions where you can sit under ABYC standards while the boat is in operation. Wyatt Fisher, the captain of the boat, said he had no confusion about that whatsoever. He knew what the designated seating positions were on the boat. He knew that 10 people were supposed to sit on the boat. And his testimony was, I knew that people were not supposed to sit on the swim platform when the boat was in operation.
Okay, but did Allie know that?
Well, Your Honor, she's passed away, so unfortunately, I don't know.
Okay, would a reasonable passenger, let's leave the operator out, would a reasonable passenger look at that upper swim platform and think, I can sit there?
Well, not with the warnings that were on the swim platform, Your Honor. And the warnings on the swim platform don't say what was just represented to you. We have a carbon monoxide warning that starts with carbon monoxide will cause death. We didn't try to hide the seriousness of that issue. And to the point that Judge Nestor asked about, the pictogram that is on that warning specifically states, specifically shows the cloud covering the entire back of the boat and a figure of a person with carbon monoxide in their lungs. It then says...
So that warning label, it seems like it's a two-level sort of seating position or swim platform,
It is.
it seems like the label is below where someone might assume it is safe to sit.
Well, the
Like the
warning,
lower level seems like, the very lower level seems like where people might assume I will dive off the boat into the back, which seems to be the common experience of people who are on recreational boats. But how would someone sitting on that top level, like unless they, like if they entered the boat from the front, how would they even know that the labels were there?
well, Your Honor, there's more than one label. And this court found in the Wost versus Washington platform case that putting a warning where the information is where it should be. That case dealt with somebody eating oysters, and they put the warning inside the menu where the oysters were located. And in that case, the plaintiffs argued, we got to put the warning about oysters on the cover of the menu.
Is the puff of smoke anywhere else?
No, it's just around the entire rear of the boat, covering the entire rear of the boat. And then the warning also says,
Right, but the actual sticker seems like it's on the lower platform, what I would call the dive platform off the back of the boat. Is it anywhere else on the boat for a passenger, a stranger to the owner's manual, or to anything that was sent to an owner, would see that puff of smoke pictorial?
I'm sorry, Jason Esther, I'm trying to make sure I understand your question. Are you asking, is there another warning somewhere
Right.
else in the boat about carbon monoxide?
Yes.
There's another warning about carbon monoxide at the helm for the captain.
Okay. And that's directed at the captain, and unless you were sitting by the captain, or especially diligent about reading warnings, you wouldn't necessarily know about that warning.
Well, you're right. If you don't read warnings that are in plain view, you're not going to know what the warnings say. I would agree with that. The language of that warning not only complies with the American Boat and Yacht Council standards, Mr. Swint, the plaintiff's expert, testified that the language of the Yamaha warning mirrors the language that is required by the standard, and the boat was inspected by ABYC, the American Boat and Yacht Council inspectors, for the location of the warning. That's where Yamaha is told to put the warning according to the American Boat and Yacht Council standards. There is a warning that right next to it that is about jet thrust that specifically, that also says you should not occupy the swim platform while the engines are running. It says it twice. And then there's another warning on the swim platform on both sides that says, do not sit here.
So whether or not those warnings are adequate to you, that's an issue of law and not an issue of fact. Whether or not that is adequate to someone who would be on the boat can be disposed of as a matter of law and not of fact by a jury.
Well, Your Honor, I think it can be, in this case, can be disposed of as a matter of law as the trial judge did. One, because it wasn't the proximate cause of Ms. Sidlowski's carbon monoxide exposure and death, as I assume we're going to talk about here in just a moment. But in addition to that, under the Mahoney versus USA Hockey case, when a warning is in plain view and it is not read, then we're entitled to the read and heed presumption. The plaintiffs say that we're not entitled to that, and they cite to this court McConnell and Boyd, both of which dealt with warnings that were covered. In the Mahoney versus USA Hockey case, the warning was on the hockey helmet, and the plaintiff said, I didn't read it. And what the Mahoney court said is, well, when a warning is on the face of a product, you don't have an excuse that you didn't read it, and that overcomes any presumption that the plaintiff would get and any argument the plaintiff would have about the inadequacy of the warning. And further, the Mahoney court went on to say when the plaintiff doesn't read the warnings that are provided, they cannot complain about the content.
Are people required to look for warnings?
Well, Your Honor, I would say yes, they are. That's what if we're talking about what a reasonable person would do. But whether they're required to or not, what the courts in Ohio find is that when a warning is provided, then the manufacturer is entitled to a presumption that that warning would have been read and followed. Plaintiffs say, well, you don't get that presumption because of the McConnell case where the warning was hidden. And that's true.
Couldn't they put on evidence to overcome the presumption? Like, couldn't they say, well, the location of these particular warnings overcomes the presumption because someone couldn't see them?
Well, certainly they could make that argument, but
To a jury.
they could, except you first have to show that it's the proximate cause of the use of the product. Ohio breaks down warnings into two levels of proximate cause. One is that it proximately caused the use of the product, and then was the use of the product the proximate cause of the injury. So first, they have to get past the level of, was it the proximate cause of the use of the product? And what the Mahoney versus USA Hockey case, that's out of the Northern District of Ohio. It's also in Lawrence versus Raymond out of the Northern District of Ohio, and is supported by this court's decision in Most versus Washington. Says is when the plaintiff does not read the warning, then they don't get a presumption that the lack of warning was the proximate cause of use of the product. We get the presumption that when the warning is provided, it would have been read and followed, and in this case, it wasn't. And plaintiffs have made the argument in their brief, well, maybe Ms. Sedlowski read the warning. You just heard counsel say that. All their experts said Ms. Sedlowski didn't read any of the warnings.
Well, okay, let's dig into that a little bit further. Of the warnings, the actual labels on the boat that would have been seen, which ones specifically warn against sitting in the back part of the boat, upper platform, rear seats, whichever one, and that doing so might lead to death?
So there are 3 warnings. 2 of the warnings are repeated. Those
By carbon monoxide poisoning.
By carbon monoxide.
Not by falling out of the boat, not by anything else, but actually by carbon monoxide poisoning.
Yeah, there is the warning that Judge Nestor and I was talking about.
Yeah,
And
the cloud, but that doesn't encompass the upper part of the boat, does it? I mean, okay,
Well, Your Honor,
let me actually change
so I've
that
got-
question. Can a reasonable person look at that warning, look at that label, and believe that that's not the boat itself, that's behind the boat?
So I put it in my outline just so I wouldn't forget what it was. The cloud goes above the transom of the boat. It encompasses the entire rear of the boat.
Well,
So I don't think a
I mean,
reasonable-
isn't the way you're describing that just like your subjective perception of where the cloud is? Like, isn't that a fact issue right there? Like whether or not that cloud goes over the rear platform or demonstrates behind the boat, isn't that an issue of fact?
Well, Your Honor, I would say no. If you look at the warning,
I think they would say yes.
clearly goes above the top of the boat. We can't agree on that?
Well, the issue is not you and me agreeing, it's whether or not, there's an issue of fact
Okay.
about that, I think.
To Judge Bach, I want to make sure I answered your question.
You did.
Completely. The carbon monoxide warning that begins with warning, which is exactly the caution that is in the Mahoney versus USA Hockey case. Plaintiffs also in their brief said, well, that's not the correct language. You shouldn't have used warning there, and that's a violation of the standard. Yet their own human factors expert, Dr. Vredenberg, testified that that is the appropriate warning language for a carbon monoxide warning, and it complied with the standard. The warning was later changed in 2024 to danger, and so they cite to that. Every model year before 2024 used warning, and Dr. Vredenberg, plaintiff's expert, said that's the appropriate language for the warning. And again, Mr. Swint testified that the language of the warning and the pictogram is exactly what the standards told Yamaha to do. Let me turn to a couple of the other issues.
But their expert says that warning was insufficient, is that right?
They did,
And your expert says the warning was sufficient.
correct.
And why wouldn't that be a question for a jury to decide?
Well, Your Honor, it's not a question for a jury to decide. Number one, my expert's testimony is not in the record, was not cited to the trial judge, wasn't considered by the trial judge. So this argument about the trial judge did not consider the evidence in the light most favorable to the plaintiff, we didn't cite any of our defense experts, and so we didn't seek to create any type of genuine issue of material fact. The reason that it doesn't create a genuine issue of material fact is exactly what I was just talking about. The presumption in Ohio, as cited in the Mahoney versus USA Hockey case and numerous other cases, is that Yamaha provided a warning and they're entitled to presumption that the warning would have been read and followed.
What about this argument about the anti-warning? For example, in the hockey case, it's like the sticker on the helmet said, "Don't wear this helmet." In this case, you're saying that you had a warning on what appears to be a seat that says, "Don't sit here."
Well, correct,
How do you
Your Honor.
respond to
And, I mean, that would go to an issue of eliminating swim platforms on boats. You asked counsel earlier, are there other boats that have swim platforms like this? Yes, literally hundreds.
I think my question was seats.
Right.
And this is another issue that I think is factual. You're saying it wasn't a seat, it was a swim platform. Wouldn't a reasonable juror, couldn't they look at this and say, yeah, you call it what you want, but this is a seat? Isn't that a factual question to be determined by a jury?
Well, Your Honor, I would say, depending on expert testimony, yes, but they don't have the expert testimony to support that opinion. So let me, if we're moving to designs, I'm happy to talk about their design claims.
So you're suggesting that a reasonable person couldn't look at this boat and say, that looks like a seat to me? That's beyond the ken of an ordinary person?
Well, Your Honor, I think it's different than that, isn't it? We're talking about whether or not it is a seat to be sat in when the boat is in operation, which is a designated seating position. I drive an F-150. I sit inside the truck with a seatbelt when I'm driving it, but when I'm working in the yard, I'll put the tailgate down and I'll sit on the tailgate, and it's got a little cup holder there for me. It's also got measuring and other things that I can do. That's not a designated seating position for my F-150. I wouldn't sit there when the boat is in operation, but as a place for my butt and a place for me to put my cold drink when I'm out working in the yard. There was no argument here from any expert that Yamaha needed to eliminate the swim platform. The defect claim that the plaintiffs are arguing to you is only espoused by the plaintiff's lawyer. He read to you Mr. Swint's portion of his report. I took Mr. Swint's deposition, and I asked him what his design opinions were related to the swim platform. Was he saying that we needed to eliminate the rear-facing seats, and that's a design defect? And Mr. Swint's testimony was no. That's not my testimony. My testimony is you should...
I don't think the issue here is whether the swim platform should be eliminated. I think the issue here is whether a reasonable person would see the upper swim platform and think that's a seat, and would a passenger have known not to sit there? I think that's the issue, not whether that should be eliminated.
Well, Your Honor, maybe in the court's view, the plaintiff's argument in this court, in its brief, and I want to quote this, was that our defect claim is that Yamaha should move the seats so they are not behind the engine inside a potentially deadly CO cloud. They don't have an expert that gave that opinion. And Adkins versus Yamaha requires that you come forward with an expert opinion to prove the very first element under 2307.75A. Do you have an expert opinion that says that this is a design defect? They don't. And Mr. Swint said, you were just read a portion from his report. I went and took Mr. Swint's deposition over 8 hours. Mr. Swint testified on pages 167 and 168. His only opinion is that Yamaha should remove the seat cushions and cup holders from the dual level swim platform. Not that it should be moved in location, which is what they're arguing here to you, and not that it would avoid Allison Sidlowski's exposures to carbon monoxide if she sat on the rear-facing seats. And that's the problem with the plaintiff's appeal, is that they're arguing issues that aren't supported by the record. They don't have an expert that gave this opinion. They're arguing things to you that none of their experts said. And
well, the reason that they wanted to remove the cushion and the cup holders is because those things encourage people to sit there.
And under 2307.75F. So plaintiffs haven't gotten past A. But if we move to 2307.75 subparagraph F, that's the part of the Ohio Code that requires the plaintiff to come forward with proof of an alternative design that would avoid the harm. And what
Is that the catalytic converter problem?
Yes, and that's
I mean, it
seems
it seems that was the thing that the trial court kind of hung its hat on, was the F portion, the subsection F.
Well, certainly that was an important part of it, Judge Nestor, because at the summary judgment hearing, the plaintiff's lawyer on page 177 said to the trial judge, we agree that you should grant summary judgment on any engine defect claims. We haven't proven those claims. A catalytic converter is part of the engine. So if you had if you had a engine defect claim, then the catalytic converter would be relevant under 2307.75F, a feasible alternative design that would have avoided the harm.
So despite what the trial court said, you're saying the trial court got it right, even though they really didn't identify that the missing expert testimony was as to the seat platform as opposed to the feasibility of the catalytic converter?
They got it right on both, because the plaintiffs were attempting to argue that, but then at the summary judgment hearing on page 177, agreed that there was no proof of an engine defect with regard to its emissions or its level of carbon monoxide, and then said on page 178, we are not even claiming the boat is defective for the lack of a catalytic converter. And he conceded those points to the trial judge for an excellent reason, because none of their experts gave them that proof. In fact, Dr. Weaver said he made no analysis of what Alison Sidlowski's carboxyhemoglobin level, the level of carbon monoxide in her blood, would have been if the boat was equipped with a catalytic converter. He said he had no opinions about a boat-motor combination that would have made any difference in this case whatsoever. So they were completely lacking proof of both a design defect and an opinion on 2307.75. And before I leave that issue,
Your time has expired. You can wrap up.
Okay. Plaintiff's counsel specifically said that's a defense. It's not a defense. Adkins versus Yamaha footnote 2 says that's plaintiff's burden. I did hope to address Dr. Weaver's testimony, but I'm out of time. If there's no other questions, the trial court's findings were appropriate and based on Ohio law. The substantial factor test in Frost versus Evenflow for causation was not met by the plaintiffs. That's what was lacking in their causation theory. Dr. Weaver specifically said that the exposure to carbon monoxide on the swim platform was normal, less than 5%. That's on page 120. And he also said normal carboxyhemoglobin levels are less than 5%. Thank you, Your Honor.
So do you think your experts set forth adequate design defect expert testimony in regards to the swim platform? That is, I guess, SWINT?
A boat designer must not put seats in a location where people could die if indeed they sat in those seats. I don't know what could be more obvious of an evidence expert testimony on a design defect than saying, don't put seats in the kill zone. I don't know what to say about this idea that Dr. Swint never said that, because I just read you what he said. Trial docket 245, exhibit BB, page 4.
Was that his deposition?
Yeah.
Right, and was there a report that was a part of this?
Oh, I'm sorry. I think that was his report.
Okay.
I'm sorry. I'm pretty sure that was his report. I'm sorry.
But there was both a report and a deposition, and
Yeah,
presumably in the deposition, the defense went after the report and tried to demonstrate that he didn't really have an expert opinion about the swim platform.
So what Dr. Swint actually said was there's nothing wrong with the tiered system that steps down to the bottom of the rear of the boat. It's the seats that are the problem. It's the putting the invitation to seat is the issue. What Dr. Swint was saying is there's nothing wrong with this idea that you can step down. That's fine. The problem is that you've put seats there so you're inviting people to sit. That's the problem. Let me just touch upon the read and heed rule, because I believe my friend on the other side missed a really important word. The presumption in favour of the defendant exists when there is an adequate warning. As a matter of law, there's not an adequate warning, so the read and heed presumption needs to be addressed by a jury, because there's a threshold requirement for the adequacy of the warning. I'm quoting from a case called Boyd versus Lincoln. It's 2008, Ohio 6143, paragraph 38. If an inadequate warning is given, a rebuttable presumption arises that the failure to adequately warn was a proximate cause of the plaintiff's injury. And that's exactly what happened in McConnell. It was a high chair, and I believe there was a sticker or a warning. It was either on the back of the high chair where a person wouldn't see it. That's this case. There's a warning. It assumed, just for the sake of this part of the argument, that warning was adequate. It couldn't be seen, and what McConnell said was, and I want to quote the words because I don't want to be accused of misrepresenting it, A warning that is inadequate because it is not properly displayed can be the proximate cause of a harm, even if the user did not read that warning. Those are issues of fact. We have a warning that's by someone's calf muscles if they're sitting in the seat, and it says, if you look at the diagram, I completely agree with you, or I completely agree with the hypothetical question that you put forth, that if someone's swimming behind the boat and sees that warning and stays there, that's a different case. This case is someone sitting in the seats. Even if you can see the warning, that doesn't tell you not to sit in the seats. And then you get behind the boat, and then you can see the warning, and then you move away, which is assuming Ali even could see the warning and could read the tiny font. That's exactly what she did. But the problem is that there's such a great level of CO exposure before that, like it was like, I don't know what to call it, the straw that breaks the camel's back, or some analogy that I wish I could come up with that was better. I also want to touch upon Dr. Weaver's testimony. Dr. Weaver addressed and reviewed two sets of tests in the back of the boat. One test came back with a very low level of CO for the conditions that day. A different test came back with results that were 145 times higher than the low-level test.
And was that dependent on wind conditions?
Wind speed and where the boat was facing in terms of the wind, and you can move the test just a little bit and it will come up with different results. So
did it matter in that test how fast the boat itself was going?
So it does matter how fast the boat is moving, and at wake surf speed is about 10 miles an hour. It's half the speed of driving through a school zone. It's very slow. It was 145 times higher in the second test. And what Dr. Weaver was asked is, if we assumed that the low test was right, would the exposure be minimal? And he said, yeah, if we assume that the low test was right. But Dr. Weaver went on to say, and I have to connect the dots here, Dr. Weaver said, it's impossible that the exposure in the behind the boat was enough to get someone to 34%. So we know that it wasn't minimal exposure because, just connect the dots, it's impossible. I see my time here is up, so I would ask that you reverse the trial court's decision and remand with instructions to deny the motion for summary judgment.
Thank you. Thank you both. This case has now been submitted, and we will issue a timely decision. That concludes our docket today.